Hello, this is Matt on the Moon Lambeau channel. Attorney Jeremy Hogan, who is a member of the XRP community and of course runs the very popular YouTube channel Legal Briefs, says that it, quote, blows his mind, well, the quote is, it blows my mind, end quote, what the SEC argues in their most recent legal filing. And I gotta admit, it is rather astonishing. The SEC has absolutely just shot themselves in the foot, and they don't even know that they did it. And so when Jeremy Hogan writes, it blows my mind, it's very easy to understand why. So I want to explain exactly what's going on here. But before going any further and digging into this, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos all up on the internets, but about crypto-related stories, but just as a hobby, just for fun. That's all that's going on here. And so the topic at hand here has to do with requests for admission. If you've been following the case, you may be aware at this point that Ripple has made 30,000, roughly, I'm rounding the number, 30,000 requests for admission from the SEC pertaining to this case. And so these requests for admission, it can be simple things. You can imagine and just make something up for a case that doesn't exist. Did so-and-so hit the blue car, yes or no? And so like that could be a request for admission. That way, going into the case, there's no dispute, and you don't necessarily need to introduce additional evidence. And so you can streamline a case by having a bunch of requests for admission just up front before the trial even starts. And so that's kind of the purpose of all of this. But in this case, there are about 30,000 requests for admission that Ripple sent to the SEC, and the SEC has been bitching up a storm about it, insisting that the judge must not require them to answer all of this because it's too burdensome, this and that, yada, yada, yada. And I want to mention, too, I do think it's rather rich that the SEC doesn't understand how hypocritical it is to complain about the burden of answering too many requests for admission while insisting that Ripple review thousands of hours of video recordings of their business meetings. Because indeed, the SEC is insisting that Ripple send over these videos because they think that it could be relevant to the case, and maybe portions of that would be. But the amount of time that would have to be spent reviewing every single one of these videos would just be insane. But and for those of you not in the know, Ripple has been recording for years and years and years all sorts of meetings because the primary reason being they've got employees all over the entire freaking planet. And so while meetings are occurring on the other side of the planet, somebody else is probably asleep. So unless you want them to be awake at 3 a.m. their time, you just record the meeting, and then they can catch up with it during their business hours the following day. So it makes all the sense in the world. Well, anyway, SEC deposed a former Ripple employee, found out that these videos exist, and then are requesting them. And it's just rich to me that they're insisting that Ripple go through all this. Ripple saying that's burdensome, and they don't see the hypocrisy here, which is rather fascinating to me. And so just to make sure we've got sufficient background, I pulled up this article. This is from October 8th. And it'll just quickly, I'm going to use parts of this just to quickly get everybody caught up to speed before we get into the new legal filing today on the exact same topic here. Anyway, Ripple has filed a letter in opposition to the SEC's request to avoid responding to nearly 30,000 requests for admission. Now, requests for admission are yes or no questions that aim to move the lawsuit forward at greater speed, as the answers provided can settle matters between parties when both sides agree on the facts. The SEC argued that answering the RFA's, request for admissions, was burdensome, as it spent more than 100 hours responding to only 254 requests. So this is about 24 minutes for a yes or no question. So, I don't have a legal background, so I don't know what the norm would be for something like this, but that sounds like a lot for a yes or no question. Now, I understand that some questions could require some digging, and you want to make sure you've got everything lined up in a row, because, once you answer this, this is all under oath, and, if they answer something, they mess up and answer something incorrectly, it could be used against them in court. So I can certainly understand whatever side you're on. I get it. You wanted to make sure that you're answering these questions correctly, but do you really need 24 minutes for every single one of these damn things? I'm not necessarily so convinced of this. And so anyway, Ripple's counsel team pointed out that filling out the RFAs exposes the SEC, as it can read in the transcript below. And so check this out. What I'm reading here is a quote from Ripple's initial response to the SEC after they're saying, hey, this is burdensome, these 30,000 requests, no. Ripple came back to the court and said, no, it's not burdensome. This is what it takes to get things done effectively. And so here's what the attorneys wrote from Ripple. The RFAs concern critical facts that defendants believe are not genuinely disputed. Truthful admissions by the SEC will therefore significantly narrow the issues for trial. The SEC does not seriously argue that the RFAs are irrelevant. Instead, it focuses almost exclusively on the sheer number of RFAs to argue that they are unduly burdensome. This is triply wrong. First, as a matter of law, the large number of requests to admit is not in itself a basis for a protective order. And second, as a matter of fact, defendants' instructions will likely require the SEC to respond to only a fraction of these RFAs, as described in greater detail below. And third, the quantity of RFAs is proportional to the needs of the case. In fact, it is driven by the SEC's own litigation theories. The largest set 6, is based on the SEC's contention that and this is highly relevant, that the SEC's contention that every offer, sale, and distribution of XRP by defendants during the relevant period, 2013 through to December 2020, was the offer, sale, or distribution of an investment contract. Now, listen to this. This is seriously important before we hop into the newer portion here. And again, this is still from Ripple's attorneys here. That contention put centrally at issue the express terms of more than 1,700 separate contracts. Yet the SEC now complains that it would be unduly burdensome to require the SEC to review the contracts it alleges are unlawful securities offerings. This is a remarkable admission. Apparently, the SEC failed to review these contracts before alleging in its complaint that every single one of them was part of a course of unlawful conduct. Indeed, the SEC seeks disgorgement of at least $1.38 billion in revenue generated by Ripple from those exact same contracts, yet says it can't be bothered to actually read them. And so, look, I'm going to comment on this just a little bit later in this video, but the SEC, my gosh, they had an easy out on this, and they completely botched this. Even me not having a legal background, I easily could have outmaneuvered here, or had a different maneuver, because right now their maneuver was to shoot themselves in the foot, as you'll see. And so at the time this happened, Attorney Jeremy Hogan put out this tweet. This is on September 30th, by the way. 30,000 requests for admissions is an astonishing number. And he noted that he typically would serve 25 to 30. But then he writes, but keep in mind that it was the SEC who decided to wait 7 years before filing the lawsuit and decided that it would argue that all continuing sales of XRP are securities. This lawsuit covers 9 years. And so, and I'm about to get to what Jeremy Hogan had to say on the most recent legal filing, but first I wanted to cover what crypto law highlighted from this document, because I'm not going to go through the whole. It's like 5 pages. I don't think it's to get the gist of what's going on here. We can highlight just a few key portions of it and talk about it. And part of it, it's highly relevant, is what crypto law, John Deaton's crypto law organization, highlighted here. And so they wrote, just added to our document library, SEC's response to the defendant's response to their request for a protective order against Garlinghouse and Larson's nearly 30,000 requests for admission. And then here's a quote from the SEC attorneys in this most recent legal filing, which was dated just, technically, I guess it's yesterday by the time I'm uploading this. But anyway, the fact that a case is complex, significant, or well publicized does not permit a party to burden its opponent with a crushing number of requests for admission. Many of the RFAs are disputed, irrelevant, or otherwise objectionable, and therefore are unlikely to result in useful admissions. Defendants recently served the SEC with expert reports that address the same issues as their 5th and 6th set of RFAs, rendering those RFAs cumulative and duplicative. And in addition to that, we'll see how the judge rules on this specifically here, but another thing that they highlighted in this most recent legal filing here, the SEC said also, we're waiting on the judge to rule on Ripple's fair notice defense, whether or not that's going to go forward. And they actually cited that this could be a waste of time. And so it doesn't make sense to do this. So I'm sitting here thinking like, the judge might rule in your favor, therefore don't do what is right. Like what the hell kind of argument is that? Does this strike anyone else as a little bit strange? They're like, yeah, well, the judge hasn't made a determination on this, so let's just not do our jobs as attorneys. Let's just go ahead and not answer these questions that Ripple's posing, even though they're highly relevant to the case, and they're pretending like they're not relevant. But they most certainly are relevant questions here. And it's just kind of absurd on its face. And so let's kind of break this down, how ridiculous this is. So now we fast forward to today, what attorney Jeremy Hogan had to say about this most recent legal filing. And he shared this screen grab from it too, and he highlighted this portion. This is what's on your screen right now. And this is from the SEC. The SEC actually wrote this. This is astonishing. They wrote, even if such an approach were appropriate, these preliminary requests purport to require the SEC to review all 1,700 agreements, which is itself unduly burdensome. Now, in case that's not clear why that's ridiculous, Jeremy Hogan spells it out right here. He says a couple things. And actually, this, I don't know if this is surprising or not, but the first thing is actually in the favor of the SEC. He's just being an intellectually honest individual. And so he wrote, as to whether the SEC must respond to Ripple's 29,000 requests for admissions, I am on the SEC side to a large extent. So I'll just pause right there. Jeremy Hogan seems to agree that the quantity of RFAs is too much unreasonable. And look, I don't have a firm stance on this since I don't have any sort of legal background, but he does. And he's like, yeah, this is a bit out of the ordinary, probably not necessary for Ripple to make their point right there. Okay. So anyway, that's his position on this. But then he said the following, because that doesn't take away from the fact that the SEC done messed up, son. So here's what Jeremy Hogan wrote. But it blows my mind, and he wrote that in all caps, by the way, but it blows my mind that the SEC has not reviewed already and is arguing that it's unduly burdensome that it actually review the contracts it is suing about. And it really is. Think about that. Like, this is what makes the basis of their argument, right? This makes up the basis of their legal complaint against Ripple. It's all like a huge part of it, right? At least is within these 1,700 agreements or contracts, whatever you want to call them here, because these are sales of XRP that we're talking about here, and they said that it would be unduly burdensome to read them, and so I'm just saying, like, why would you write that? Why would you admit that? And so Jeremy Hogan responded to his own tweet there, and he wrote, I am just adding to this tweet to add a couple more exclamation points and question marks about this, which he did. It's on your screen right there. Thank you. And so clearly he was absolutely blown away by this admission that they made a legal argument against Ripple, filed a complaint, and we've been dealing with this for the last 10 months as a result, and they didn't even read the documents that would have made, like you'd have to be aware of the contents within these before bringing this suit. And they didn't, it's on your screen, they didn't read it. They didn't read the documents, which are highly relevant in determining whether or not it makes sense to go after Ripple or not. They didn't even review the damn information. What an admission. So this is why Jeremy Hogan is saying it blows my mind, and he wrote it in all caps. That's the reason why. Now, there's a legitimate question, and some of you may have thought this as well. I actually did too. Somebody within the community named Cursed Knowledge wrote to Jeremy Hogan and said the following. I'm confused. If you are largely on the side of the SEC in regards to the SEC's lack of need to respond to the requests, why does it matter if they've reviewed the requests or not? Why care if they've reviewed something you believe they have no obligation to respond to? Which is a totally fair question. Why are you saying that they shouldn't have to respond to these 30,000 questions if you don't think that they should have to respond to that? Why do you think that they should have had to have reviewed these documents in the first place? And so I'm going to give you my answer first, and then I'm going to read what Jeremy Hogan had to say in response to this. Because here's the deal. The SEC answering 30,000 requests for admission, so 30,000 questions, that's what's posed to them. The SEC answering 30,000 questions is not the same thing as reviewing 1,700 contracts or agreements before bringing a lawsuit. Why? Because they could have reviewed all 1,700 contracts without being faced with 30,000 questions before filing suit against the SEC. So think about it. Before the suit was brought, in their own little vacuum here where they're trying to decide whether or not to bring the suit, if they did the right thing, they could have just in a vacuum reviewed these 1,700 documents without being bombarded by 30,000 questions from Ripple. They're two separate things. Reviewing the documents, getting bombarded with a ton of questions. And you might think that you have to have one if the other exists, and I say no, and I can explain why. Let's just say that at the heart of a legal case is a bologna sandwich. Because why the hell not? Why not a bologna sandwich? Do you have any idea how many questions I could come up with about a bologna sandwich? Did your bologna sandwich have ketchup? Did your bologna sandwich have cheese? Did your bologna sandwich have mayonnaise? Did your bologna sandwich make you feel sad inside when you ate it? Like, I could, seriously, give me a little bit of time. I can come up with an absurd amount of questions, bombard you with questions about a damn bologna sandwich. And then there's other topics to talk about, and then I can just come up with all sorts of stupid-ass questions. So what I'm saying is, there can be such a situation where you're bombarded with questions. Maybe some of them actually are duplicative and not necessary. But what I'm saying is, just because those, or even if it is the case that those 30,000 questions, that's just too much and Ripple really is engaging in overkill, it still could be the case that you did read all of the documents. But here, they're admitting that they didn't. They didn't need to do that. They could have argued that it's too many questions, but we did review the documents. They absolutely could have. But they didn't, because they're freaking idiots, and I love it, and I'm so happy for this. I am so happy for this. Like, isn't that astonishing, though? My gosh, it's like Ripple set a trap and they freaking fell for it. That's what it kind of looks like here. Because Ripple had to know that they'd bitch up a storm, and perhaps they even thought that the SEC would slip up to this degree, claiming that it's burdensome. Maybe that was part of the strategy. I could certainly see that, and they certainly fell into the trap here. Again, read this. This is what Jeremy Hogan highlighted. Even if such an approach were appropriate, these preliminary requests purport to require the SEC to review all 1,700 agreements, which is itself unduly burdensome. These are like, do you even lawyer, bro? I'm so glad you made this mistake, but do you even lawyer, bro? I'm thinking the answer might be no. Because you absolutely could have said, of course we reviewed all of these documents, but this is too many questions about those documents. It's not that hard to make that argument. Man, sucks to suck, right? Jeez. So I'm just saying. But anyway, so Jeremy Hogan, in answering that question from Curse Knowledge, wrote, "It doesn't really matter as to this motion, but it's a big problem if the issue ever becomes whether the lawsuit was frivolous or not. Why a lawyer would ever type that into a document, I don't understand." Yeah, exactly. And so this is why he wrote in all caps, it blows his mind. That's exactly why. And it is mind-blowing, and I'm very thankful for it, right? So that's where we're at right now. Oh, gosh. Man, the SEC sucks. Bunch of asshats. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.